thank you for staying with us. Now, President Cyril Ramaphosa has filed papers at the Constitutional Court to review the Section 89 panel report. The report into the 2020 burglary at his Limpopo farm found that he may have a case to answer to. So let's bring in some legal expert now. Advocate Modidima Mannya joins me this morning to look into this matter. Advocate, thank you so much for your time and good morning to you. And let's start with the President's decision to approach the ConCourt to obviously review Section 89 and that panel's report and their findings. What exactly is the President trying to do with this route via the ConCourt?
Well, good morning and good morning to your viewers. I think the President, and one can glean that from his application, that he believes that this matter is so important and serious because it involves also the removal of the head of state. And I think to me you will recall that this would be the third president who would be removed in more or less similar circumstances. If you remember, former President Mbeki was removed from office. There were all sorts of allegations made. You will recall that at a point there were accusations that took about 18 months to clear. Former President Zuma did not finish his second term as well. There were all sorts of allegations. President Ramaphosa is facing the same situation, and he thinks that's important when I look at his papers that this matter be dealt with because it's a matter of grave public and national interest.
If found successful, if his pursuit with the ConCourt is successful, what would that look like? What would that look like then for the President?
Well, look, from the papers as they stand, I don't get a sense that the President says, I don't want to be held accountable. I think he's basically saying, I want to be held accountable in a proper manner. And you can see also with the reasons that he advances. And one of them is a very pertinent issue. He says that I should be found to have acted in bad faith, deliberate and in bad faith. And of course, that's an understanding that anybody can make a mistake, including yourself. The question is whether this mistake was made in good or in bad faith. And he seems to suggest that throughout whatever happens, and even if it's found that he may have misconducted himself or broke the law, but he acted in good faith.
Yeah. In your legal opinion, Advocate, what chances does the President have in terms of being successful in that manner, as also because a lot of South Africans were questioning why in the first place he went and pursued the ConCourt, and why didn't he allow, of course, the findings to allow him to be questioned either in Parliament or the NEC, as we've heard now, saying that they would not actually be voting against this finding. But in terms of your legal opinion, why do you think he first went to the courts, and what's the likelihood that he will indeed be successful at the ConCourt?
Well, to me, firstly, the principle in law is that when public functionaries have taken a decision, they do not have the right to change their decision. So assuming the panel itself were to wake up one day and say, look, we think we made mistakes here, they can't simply just say, okay, we want to correct the situation. You'll recall that Chief Justice Zondo, in his capacity as chair of the State Capital Commission, at some point approached the court to correct part of his report. The only way, once a decision has been taken by a public functionary to correct it is by way of a judicial review. So you have to go to court either way. The NEC of the ANC is not a state. So the decisions they take are party decisions because they are a party represented in Parliament for the guidance of their members, but they cannot take decisions on behalf of the state. That is why even whatever decision the NEC takes, it will still have to be implemented by the public functionary.
Right. What's then the recourse here for opposition parties? Many of them have called the President to step aside, to step down, to resign. The DA went as far as saying the National Assembly needs to be dissolved. At this stage, what's the possible recourse?
Well, the only recourse in a constitutional state under the rule of law is to join the application of the President and oppose. Obviously the statements that are made, some are just ridiculous political statements. The president has got the right. Remember, a number of opposition parties have in the past taken parliament to court, and nobody asked them, why don't you just flag it out in the National Assembly or in the NCOP? Why do you go to court? In fact, the rules which are governing this impeachment process are the product of an application by the opposition parties to the Constitutional Court. So, what is good for the goose must be good for the gander. So the political parties must not conveniently tell us when people should go to court or should not go to court. All of them go to court. If you look at the lot of judgments that are there, the public protector judgments, the eNCA judgments, all of them are spearheaded by political parties. Why don't they go and flag it out in the National Assembly?